From the News Channel 5 Network, this is MorningLine.
Thanks for joining us on Morning Line. I'm Aundrea Cline-Thomas filling in for Nick Barris. Today's show is really a treat. All of those legal questions that you have that you've wanted to ask, that you probably have to go into somebody's office and pay quite a bit of money to ask, you can ask them today for free. Today's show is Ask the Legal Expert. Our expert, very familiar to all of us here, is Andy Allman. Thanks for joining us this morning. First, tell us about yourself and your practice.
We're a law firm primarily located in Hendersonville in Sumner County. We do employment, labor law, and some civil rights work. The majority of our practice, we really focus on representing employees who've suffered a termination, a demotion, a suspension, failed to be promoted, some type of adverse employment action where the employee feels or believes that it's due because of maybe their gender or their age, their race, religion, national origin. They might have a disability or they might just have a medical condition that the employer perceives to be a disability. We represent quite a few employees who've engaged in whistleblowing activities. They've refused to participate in illegal or unethical conduct at the request of the employer, or they've reported their employer to a particular regulatory agency and been fired or demoted or suspended. On the civil rights side of it, we focus on employees of governmental employers who maybe have been terminated for exercising the First Amendment rights, freedom of speech, things along those lines. We do also handle cases that deal with law enforcement, maybe excessive force cases, wrongful arrest cases, things along those lines.
So it runs the gamut.
Pretty much, yeah. The Civil Rights Act really encompasses not only what the government may do out in the private sector or the public sector, but from that Civil Rights Act is where we get a lot of the laws that really strive to ensure that employees are treated fairly in the workplace.
All right. We want to get you all into our conversation to ask all of your legal questions. 737-PLUS is the number, 615-737-7587. Please give us a call. We're going to continue our conversation, but we want to also hear from you. Well, you were talking about police force, and, you know, that has been all over the news with Ferguson, Missouri. Kind of tell us how you're watching it. I'm sure it's with a different lens.
Well, it is. You know, on the one side, you've got all of the emotion that is boiling up and boiling over, as we see in the riots there in the city. I guess from my perspective, when you kind of understand how the law looks at that type of situation and how it treats it, you begin to start talking about the elements of the claim and what would be necessary to prove that this officer used excessive force when he shot the young man in the street. And a lot of people really have a misunderstanding of what it takes if you're going to file a claim for excessive force or violation of a citizen's right. When an officer uses force, you really just can't walk into a courtroom and say that officer shot this young man in the street, therefore we're going to hold him accountable, or he's liable, or the city is liable. Those types of cases are some of the toughest cases to prove and to prevail in, because you've really got to go beyond the actual act of the shooting to hold the police department or the city responsible. You've got to prove what we call a policy, practice, or custom that shows that this city or this law enforcement agency really kind of has a pattern of violating the rights of citizens, either through turning a blind eye to this type of conduct in the past, a failure to train the law enforcement officer, which is what we're really hearing a lot about when we talk about the militarization of our police department, which I think is going to be an important component to this analysis. But or that it was just some type of an intentional act that what we call the ultimate policy maker, the ultimate decision maker, usually the chief of police, has put in place that directly led to that shooting. So it's a pretty complicated claim. It's not something that you can just say someone was shot and they may have been unarmed, therefore this officer is going to be held liable or the police department is going to be liable. It's a much deeper investigation.
Yeah, so, you know, a lot of people that have been protesting have been saying, charge the officer, but you're saying that it's not that simple. You can't look at the case just in a silo, essentially.
That's correct. You can't really look at it in a vacuum. Now, what I've been describing is the civil accountability. If the young man's family were to bring a civil lawsuit for wrongful death, for excessive force, something along those lines. Now, it's my understanding from looking at the news reports that this case has either gone to the grand jury or is headed to the grand jury.
Today.
And that's really going to be the criminal aspect. That's when citizens in the community are going to sit down. They're only going to listen to a certain percentage of all the evidence that is out there or that we may uncover as the investigation goes along, just to see if there's enough probable cause to charge that officer. In a grand jury, that burden of proof is not very high. It doesn't take a whole lot for a grand jury to hand down an indictment, but that's the first step. That's the first part of the process when we start talking about criminal accountability for the officer.
What about the arrests of journalists that we saw, especially, you know, at the beginning especially?
Yeah, I was a little shocked about that. The TV was on and CNN was on, and I saw the report about that, and then there seemed to be quite a bit of confusion or chaos, if you will, about telling the media that you need to be standing in this place and then moving them around and really getting physical with some of the members of the media. That struck me as kind of odd. I think the arrest of, just from what I know, what I've seen on television, I think the arrest of some of the members of the media was an error, and I think there's probably going to be some changes in policy and practice and custom at the morning officers meeting when we start talking about, you know, when and if you can arrest members of the media for reporting the news.
And we've talked about it here on MorningLine earlier this week. How do you think that other police departments should be looking at this from a legal standpoint so other departments don't get into these problems?
Well, a shooting, okay, is nothing new to law enforcement.
Right.
A shooting that results in some type of civil litigation following up is not all that uncommon across the country either. And I think what we have seen in the past is that when those happen and they get reported and there is some type of either criminal accountability or civil litigation that follows, that information is shared amongst law enforcement all across the country when they go to seminars, when they do in-house training, when they go to review their policy and procedures manual. So I think for the most part, you see law enforcement looking at things that happen and then looking at how they do business, if you will, and trying to see if there is room for improvement. I think that one component that has really been brought to light in this instance that's really kind of a collateral issue to this, but I think is one that we're going to be using as we move forward in some of the cases that come along when we talk about excessive force and a lack of training, is the overwhelming amount of military equipment that our law enforcement had. You know, I can honestly say I had no idea that a lot of law enforcement out there have these tanks, armored personnel vehicles. I saw a report, well, one law enforcement agency has grenade launchers. I'm not really sure who a police officer is going to be launching a grenade at. So, but then I'm also hearing military analysts that are on television that are engaging in the conversation talk about they look at the video footage of these officers using the equipment, and just that brief glimpse of watching them, they say they're not even trained on specifically how to use that in an appropriate manner. That lack of training is a component or a factor, if you will, when I go to prosecute a civil litigation for excessive force, wrongful arrest, something along those lines. Was that officer trained appropriately? Wow, okay.
And we want to take your questions. It's not just about police force. We can answer. You can answer.
We hope so.
I can't. All of your legal questions at number 737+, 737-7587. And We're going to hear from Sue. Sue, thank you for calling Morning Line. You're on the air.
Thank you. I've got two quick questions.
Yeah.
First of all, in a Rule 60.02 motion, it lists several reasons that you can file that motion. One of them is surprise, and I'd like to know if there's a legal definition of surprise or what exactly is meant by that. And the other thing is, what do you do if, normally if you're going to appeal something, you appeal from an order. What do you do if the judge refuses to issue an order?
Okay, thank you, Sue. First, what is a 60.02 motion?
A Rule 60 motion is a motion that can be filed after the entry of what we call a final order. And a final order is a document that is drafted and signed by a judge that resolves all the issues amongst all the parties in a particular case. Mm-hmm. And what we say is in a Rule 60 motion is that, look, there is some form of error that we want to bring to the trial court's attention, the factors that she talked about, and she listed one being surprise. We say to the trial court, look, there's an issue here you really need to revisit before we spend the time and resources going through the appellate process. We think we can be taken care of at the trial court level. Mm-hmm. So it's a mechanism of review of an order without having to go all the way to Court of Appeals, because that Rule 60 motion can normally be resolved within 30 to 60 days, whereas the appellate process can sometimes take a year and a half. Okay. She's asking me about the definition of surprise, and kind of just let me give you kind of a rule or maxim, if you will, that is true amongst every area of the law. When we look at a rule of civil procedure, we look at a statute, we look at the law, the courts routinely say that we basically give a Webster's dictionary definition to the words in it. So all she has to really do is kind of take the word surprise, look it up in Webster's dictionary, get that definition. Now, what she can do, I don't know if she has access to any type of legal research for cases out of the appellate courts, she can then look at case law and look how appellate judges have used the definition of surprise when they're analyzing a Rule 60 motion. But there's really no special hyper-technical definition of the word surprise. It's kind of the same definition that Webster's gives it in the dictionary.
Okay, fantastic. Now, we would like you to get in on our conversation. Again, 737-PLUS, 737-7587. We hope to take your calls when we come back from this break.